When does bullying in the workplace become illegal? Generally speaking, there are no laws in the state of California that directly prohibit bullying. It is not illegal to be a bad boss who micromanages, yells, screams, name calls, or just makes the workspace miserable for workers. But there are times when bullying becomes illegal. Generally, this is when the bullying creates a hostile work environment under the law. A hostile work environment occurs when there is harassing conduct that is severe and pervasive, meaning it is egregious and happens more than once, generally related to a protected class such as race, gender, age, or religion, that a reasonable person would find to be hostile, intimidating, offensive, or abusive, that the employer knew or should have known about but failed to take steps to remedy. While not all bullying is illegal, there are several categories of bullying that would meet the legal definition of a hostile work environment. One example is race-based bullying. Race-based bullying could be repeated teasing, telling of jokes, or policies or practices related to race. Classic examples include repeated use of racial epithets, displaying racially offensive items such as nooses or swastikas, or using stereotyped language to describe the members of certain races. Sex-based bullying can also rise to the level of an illegal hostile work environment. Name-calling, stereotypes based on gender, or conduct or language disparaging sexual orientation often evidence a hostile work environment. In fact, any bullying that is because of the employee's membership in a protected class, such as race, sex, religion, national origin, etc., if pervasive or severe, would likely rise to an illegal hostile work environment. Bullying that creates an unsafe work environment includes physical assault or threats of violence can also rise to the level of a hostile work environment. Another type of bullying is in retaliation for engaging in a protected activity, such as taking leave, complaining about illegal conduct or a safety issue. It is illegal for an employer to treat you poorly because you exercised your rights. Let's look at a couple of scenarios. Patricia is an employee at Acme Inc. Patricia is a 32-year-old Mexican-American employee. Patricia is the only Mexican employee in her office. Her boss likes to hire family members and gives those family members special treatment. Her boss has never really liked Patricia and often ignores her and doesn't help her with her work by answering questions or responding to her requests for assistance. When Patricia's boss does speak to her, it's often in a rude and condescending tone, and Patricia's boss often yells at her when she makes mistakes, calls her an idiot and stupid, and frequently uses foul language. Patricia's boss treats many of the employees she doesn't like this way, but is different with her favorites. Patricia doesn't know why her boss acts this way, but doesn't believe it's because of her race, age, gender, or other protected class, nor has Patricia engaged in any type of protected activity recently. This treatment is causing Patricia a lot of anxiety and even depression. While Patricia's boss is likely a bad manager and the company should do something about it, Patricia's situation likely does not rise to the level of an illegal hostile work environment because the harassing conduct is not related to a protected class such as race, age, or gender, nor is it in response to Patricia engaging in a protected activity. Let's look at a slightly different scenario. Yvonne is also an employee at Acme. Yvonne is an African-American woman over the age of 40. Yvonne's boss frequently yells at her and calls her names such as lazy, senile, and ghetto. When Yvonne complained to Human Resources about this conduct, she was told that she was being overly emotional and that she had an attitude. Yvonne's boss found out about her complaint to Human Resources and since has been ignoring her. Yvonne's boss will frequently exclude Yvonne from staff meetings. Yvonne's boss also invites other employees out to lunch, but not Yvonne. Yvonne's boss has also become hypercritical of Yvonne's work and points out every mistake, even ones not pointed out before Yvonne's complaint to Human Resources. A few weeks after her complaint, Yvonne received a performance evaluation stating she was not meeting expectations and the company demoted her to a lower-paying, part-time position. Not only is Yvonne's boss a bad manager, but she is likely creating an illegal, hostile work environment. The names the manager called Yvonne can be linked to a protected activity. Words like senile can be linked to age and lazy and ghetto to race. HR's description of Yvonne as overly emotional, aggressive, and having an attitude can also be linked to race and gender. Additionally, after complaining to Human Resources about what could be race, gender, and/or age discrimination, Yvonne was subjected to retaliation in the form of being ignored, increased scrutiny of her work, and being excluded from meetings. Yvonne suffered an adverse employment action when she was given a negative performance review and demoted with a decrease in her pay and hours. If you have experienced what you believe to be a hostile work environment related to a protected activity or membership in a protected class, contact an attorney to analyze if the bullying is actually an illegal hostile work environment or retaliation. Be prepared to discuss with the attorney why what you experienced wasn't the bullying of a bad supervisor or poorly supervised company, but rather meets the legal definition of a hostile work environment. Be prepared to show facts that support your belief that a protected class or protected activity was the reason for the bullying. This is just a bit of information about bullying and hostile work environments. For more information or to discuss your particular situation, please reach out to eJustice Project. We may be able to help.